For the topic of my discussion, I've chosen to talk about the ethical dilemma of the minors' rights to confidentiality. I thought that would be especially relevant considering that I will be a school counselor and will be working with several minors. In regards to confidentiality, that's like a pledge or a promise per se that what is shared in the counseling session will not be immediately disclosed except or with the only exception of conditions previously agreed upon. And the confidentiality is important because without this, students or clients seeking help might not be as likely or feel as safe or as comfortable in sharing the information that they need to share or seeking help. The ACA Code of Ethics and Standards of Practice and Ethical Standards both refer to standards for counseling minors, and they agree in some respects, such as when they should be broken, when the confidentiality should be broken, suspected child abuse, harm to self, and in cases where there's clear and imminent danger to others. However, counselors vary on their definitions as to what imposes clear and imminent danger. And neither of the guidelines give specific answers to all situations that counselors will encounter. In making decisions, it's very important that the counselor consider what's in the best interest of the client. Also taking into consideration the ethical codes, the legal considerations, and the statutes or laws in their state and policies of their district, and that can vary district to district as well. In most cases, the law has not given confidentiality rights to children, but those rights are evolving. And then comes the question, what exactly is a minor? Because that's not exactly clearly defined in those codes. So in general, a person 18 years of age is no longer considered a minor. They have the right to vote, and the right to privacy is transferred from the parent to them at that point. So that's kind of set a precedent with the right to vote, with the 18 years of age being considered no longer a minor. There's some conflicts of interest. Counselors have to use professional judgment in deciding exactly what information and to what extent that information should be shared in the school setting with teachers and with parents. Again, the idea is that there would be a collaboration, and the idea would be to always do what's in the best interest of the child. And the primary obligation is to the client. However, that can conflict sometimes with the legal and parental ideas of the minor's rights. So that's where the professional judgment of the counselor kind of comes in. As far as dealing with parents in the school setting, a proactive stance is the best stance. So it's good if you can have an open dialogue with parents, and if parents know exactly what confidentiality means, what the right to confidentiality means, what are the code of ethics. You could even provide a copy for the parents of that, or if there is a handbook that lets the parents know right up front what the policies are and what exactly that entails. Some things about parents' right to know. Again, it's at the counselor's discretion up to a point as to what to divulge and to what extent to divulge. However, the parent is the legal guardian, so that also has to be taken into consideration. Some ways to avoid compromise of confidentiality while at the same time respecting the parent's right. One of the things, as said before, is that the boundaries could be clarified and discussed, and you could listen to the parent with an empathetic ear and and help them understand that you understand their concerns, and could even ask the child about the desired information and explain to the parent the nature of the relationship, that the confidentiality is not a good thing. It's a sign of them becoming independent individuals and not so over dependent, and at the same time helping them along their journey. As far as what to share and when to break confidentiality, the codes are fairly clear at that, although there is some difference of interpretation per counselor. The challenge is in finding a balance between the professional code of ethics and legal concerns and all the parties involved in the school and community setting. But in the end, it still comes down to what is in the best interest of the particular child. So, still considering the state statutes, legal and ethical obligations, but how can I best help my client? So, in situations where an answer is unclear, the professional judgment of the counselor will come in, always considering what the rights are, but what will serve the best purpose for the client and for the client in society.